Welcome to the deep dive. We take all the source material, the legal filings, the dense articles, and we just cut right to the chase for you. It's really the shortcut to getting fully up to speed. So today we've got this massive legal chess match going on in Guyana. It involves two really prominent businessmen, Nazar and Azruddin Mohamed. They're facing an extradition request from the U.S. on some serious charges, wire fraud, money laundering. But here's the thing. The immediate fight isn't actually about whether they're guilty or innocent. It's this high-stakes constitutional showdown that's all about timing and, well, legal standing.
That's it, exactly. And it's a brilliant tactical move by the defense, whatever you think of the legal merits. The source material shows they're trying to stop the entire train before it even leaves the station.
Yeah.
And the prosecutors are pushing back hard. They're urging the principal magistrate, Judy Latchman, to just, throw the whole argument out.
Throw it out completely.
Yes. They're calling this constitutional challenge frivolous and vexatious, arguing it's an abuse of process. Their core claim is, look, the defense is trying to raise these huge issues way, way too early.
Okay, let's unpack this. So if the issue is timing, what's the specific move the defense is making to get this heard now?
They're making a pretty aggressive play to skip a few steps. They want an immediate referral straight to the High Court, and they're citing Article 153, Score 3 of Guyana's constitution. Their argument is that the magistrate's inquiry, which is happening right now, is already breaching their fundamental rights. So they're saying these big constitutional questions have to be settled first.
Right, and this is where the prosecution just draws a hard line. Prosecutor Terrence Williams and his team are arguing, no, Article 153 just doesn't apply here, not at this stage. They're saying the magistrate's job is super specific. Just determine if there's enough evidence for a committal. Are the technical boxes for extradition ticked? Her job isn't to get into these huge constitutional debates.
So there's an established procedure for this. A very specific roadmap, yeah. The prosecution says the right time for the Mohammeds to make this challenge is after the magistrate's court finishes its job and commits them for extradition.
And once that happens, what's the next legal step for them?
At that point, the proper tool is a habeas corpus review in the High Court. For you at home, think of habeas corpus as the state having to, produce the person and justify why they're being held. That's the moment the defense can really argue that the detention is unlawful on constitutional grounds. Then, after that, they can appeal on points of law.
So by trying to jump straight to the High Court now,
they're jumping the queue. The prosecution says it's a total misuse of the process.
that phrase, frivolous and vexatious, that's really loaded legal language. Williams literally said, there are no real constitutional issues, and they certainly do not arise for consideration at this time. Is that just confidence, or is it also a tactic to pressure the magistrate?
Oh, it's both. It's definitely both. But it's mainly procedural certainty. Frivolous, in this context, means it has no serious legal basis at this time. So the prosecution is saying, look, we're not even getting into the merits of your claim yet. We're just saying the timing is wrong.
And if the magistrate agrees with that?
It accelerates everything. It pushes the case right toward the committal stage, which is exactly what the defense is trying to avoid.
So this procedural fight is everything. If the defense wins this first battle and gets that referral, it could put the whole extradition on ice for, years? Well, the constitutional stuff gets litigated.
Potentially, yes. It becomes a procedural shield.
And the prosecution has precedent for this, right?
They do. They have a crucial precedent about liberty. They point to a previous ruling from Justice Joanne Barlow, which basically confirmed that a magistrate is the right person to handle this kind of inquiry. But the real kicker is what that ruling said about the Constitution itself. Justice Barlow's ruling honed in on Article 139 of 1 of the Constitution of Guyana. It guarantees personal liberty, but, and this is a huge but, it contains a very specific lawful exception.
And what does that exception say? Because that sounds like the prosecution's ace in the hole here.
It really is. Article 139 explicitly allows for the deprivation of a person's liberty for the purpose of affecting his lawful extradition or removal from Guyana.
Wow. Okay, so the Constitution itself says your right to liberty can be suspended for the purpose of a lawful extradition.
Exactly. So the defense's broad claim that just being in this process violates their liberty gets really, really difficult to argue. The ground completely shifts.
So the prosecution's point is that the magistrate's only job is to check if the process is lawful, not if the law itself is constitutional.
Precisely. They're saying the rights the defense is leaning on expressly exclude extradition from consideration at this preliminary stage. Her job is gatekeeper, not constitutional referee.
Okay, here's where it gets really interesting, though. Because even if the defense loses on the timing, they have this whole other line of attack. They're not just challenging the process, they're going after the actual law being used against them.
And this is the constitutional juggernaut. They are challenging the 2009 amendments to Guyana's Fugitive Offenders Act. This isn't some small technical point.
What's their argument?
It's sweeping. They argue the amendments hand unchecked power to the executive, specifically the Minister of Home Affairs. They're saying it lets a political appointee basically bypass the courts, and as a result, it undermines judicial independence and violates all these fundamental rights: fair trial, equality before the law, you name it.
Okay, to get why this 2009 law even exists, we have to talk about the 2008 Barry de Turam case. Why was that case such a big deal?
The de Turam case was a huge shock to the system. De Turam actually managed to block his own extradition to the U.S. because the treaty being used, this old 1931 UK-U.S. treaty, was missing a key protection for him.
A protection?
Yes, a clause called the specialty rule. And because it was missing, the court sided with him. That ruling was seen as basically crippling Guyana's ability to extradite people to the U.S. It created this massive legal gap that Parliament felt it had to fix, and fast.
All right, let's pause on the specialty rule for a second, just to make sure everyone's with us. What is it exactly?
Think of it as a diplomatic promise. If Guyana sends someone to the U.S. for wire fraud, the specialty rule is the U.S. promising we will only prosecute them for wire fraud. And crucially, it also means the U.S. can't then just turn around and ship that person off to a third country, like Canada, to face other charges without Guyana's permission. It stops countries from playing past the parcel with a fugitive.
Got it. So de Turam won because that promise wasn't written down in the old treaty. How did the 2009 amendment fix that?
Well, the prosecution says Parliament stepped in specifically to correct what they call the flawed de Turam ruling. And the 2009 Act did that by making a really critical change. It basically says that even if a treaty doesn't explicitly have the specialty rule, the Minister of Home Affairs can approve the extradition anyway if they decide it's in the interest of justice.
Ah, and there it is. That's the phrase, isn't it? Interest of justice.
Mm-hmm.
That's what the defense is pointing to as unchecked executive power.
That's the flashpoint. Because it suggests that if a judge finds a legal flaw in the treaty, the minister can just override that finding based on their own subjective call. That's the whole basis for the claim that judicial independence is being undermined.
But the prosecution has a counter to all this.
Mm.
And what's fascinating here is it's not just about the rule, it's about who even gets to complain about it.
Yes, and this is the standing argument. It might be the most powerful weapon they have. The prosecution's point is simple. Extradition is a deal between states. It's a contract between the government of Guyana and the government of the United States.
Not the individual.
Not the individual. They cited older Court of Appeal decisions that held the specialty rule is not a personal right for the accused, which means that the Mohameds have no standing to challenge it.
So they're saying, even if the U.S. were to break the specialty rule later on, only the government of Guyana could complain. The accused person themselves has no legal right to raise it as a defense.
That's the exact legal position. And if the magistrate accepts that, it just completely neutralizes the defense's reliance on the de Turam case.
So the prosecution is basically arguing that the de Turam case itself was wrongly decided.
They are. They're saying it contradicted the higher Court of Appeal authority, and that's the error that Parliament had to step in and correct with the 2009 Act.
Which means if the magistrate agrees de Turam was wrong, the defense's whole constitutional challenge to the 2009 Act could just collapse.
It could. It's a very powerful 1-2 punch from the prosecution.
So, I mean, where does this leave us? It feels like Magistrate Judy Latchman have two enormous decisions to make that will shape this entire case.
That's right. First is the procedural fight. Is this constitutional challenge premature? Is it frivolous and vexatious? And do they have to wait for the habeas corpus stage?
And second, the really big one. Do the Mohammeds even have standing to challenge the specialty rule and the 2009 law in the first place? If she says no, that's a massive blow to their defense.
And if we just, connect this to the bigger picture, this case really shows you the fundamental tension in international law. It's this constant balancing act.
Between what?
Between a state's need to honor its treaties, its international obligations, and its absolute duty to protect the constitutional rights of its own citizens. The outcome here is going to be huge, not just for these two men, but for clarifying those boundaries between the different branches of government in Guyana.
Which leaves us with a final thought for you to chew on. If a parliament passes a law like this 2009 Act, with the explicit goal of overturning a court ruling it disagrees with, like the Dataram case. Does that action, by its very nature, blur the line between executive power and judicial independence, just like the defense is arguing? I mean, what does it really mean for the rule of law when one branch of government legislates to correct a problem it thinks was created by another? Something to think about as the magistrate decides whether this is a legitimate defense or just a delay tactic.